So everyone, I'd just like to just say good evening. I'm Vanessa Lowry Brown, and it is a pleasure to be on this call with the Registrar of Wills today. Without any further ado, I'd like to introduce to all of you the Registrar of Wills. This is a woman who has a heart for the community. She is really concerned about connecting all of the funeral directors and pastors to her office so that you have a direct line so that we can make sure that our constituents are expedited at their time of need. So without any further ado, everyone, I welcome to this call our Registrar of Wills, Tracey Gordon.
Thank you. Thank you to the honorable staff, members of the Funeral Association and just pastors that, I'm just excited that Vanessa is working with you all. I would like to kind of toot Vanessa's horn. Even though she was not my state representative during the time that she served, whenever I had a problem, I would call her, and she had a staff that that was very attentive to all my needs and solve problems. And so that's what I do over at the Registrar of Wills. It's called solving problems, because you have to remember that our office is when constituents come at the happiest of times and the saddest of times. The happiest of times is where I serve as clerk of Orphans Court, which oversees marriage licenses and records. And also we serve as the clerk for guardianship purposes. The saddest of times is when someone dies in your family, and either one or two things, they're prepared for the death or they're not prepared for the death. And if they're prepared for the death, normally they have some sort of will, whether it is official will that was made for them with the assistance of an attorney, or just a plain piece of paper listing the assets and where you wanted them to go to with a signature that could be verified. The worst of this is when they come to you and they don't know where to start. They don't know anything. There's no will. There's no information at all, barely information about the bank account. And so you all provided us some questions, and some of those questions was, what services does the Registrar of Wills provide? Well, I serve as the administrator I oversee the protection of your generational wealth. That is my job as an elected office. This office has been in existence since the 1600s. Since when the Quakers came over and got land and divvied it up, these white male landowners wanted to make sure that they protected their wealth and protected it so they can pass it down through generations. And so the fact that right now, the average person, and particularly Black Americans, only about 25% of us even think about making wills, is causing a lot of problems. We're losing a lot of generational wealth, and it's causing a lot of headaches when it comes down to when that person dies, the ability to take care of the business in a smooth manner. And so we've came up with flyers, and we came up with, we are on all social media sites, and you can actually directly get in contact with me through Vanessa. We will make sure any problems that you have with your customers not understanding the process, we will make sure that they get our undivided attention. And so some of the things I do at the Registrar of Wills is I validate the will, I collect inheritance tax and estate taxes. We probate estates, and probate estates is when you come to our office with the will or without the will. So you can either, if you're the executor with the will, or you're going to be an administrator without the will, but you're coming to us so you can secure the assets, pay the debt, and then distribute those assets. We also assign executive privileges. We issue short certificates, and those are the certificates that you need to be able to go to those banks and get the money out, depending on how much is in that account. And also, we preserve and protect records and archives. So we have all marriage records dating back to like the 1800s. If your mother and father got married in Philly, we have that record. If your grandmother and grandfather got married in Philly, we have that record. Some people use us, come and get records just for genealogy purposes. And uh, other people just come and get records because they have to get the real ID. Some people think that our office deal with death certificates, and we don't. And we're going to go over that too. I also am charged with preserving and protecting all these records and archives. All these records that's dating back to the 16, 17, and 1800s. It is my responsibility to protect those records. And so we have all kinds of proposals that's going out to help me preserve those records. I just wanted to clarify with you all to let you know that this is not a city office. This is a state office, and we follow the first judicial code. So we're we're under the courts. So mainly a lot of people think that that's a city office, and it's not a city office. This is a state office. We are one of 67 counties, and we're considered first class. And the last thing I think that I wanted to let you all know is that what I do is I serve to protect your generational wealth. And I campaigned on three things. I campaigned on one is to make sure that everybody in the city of Philadelphia understood what we did, deal with these tangled titles, because many of your customers and many even families and friends are living in houses that are in a dead person name, sometimes generations back, and they can't conduct business with those houses. They can't sell them. They can't pass them down to their families. They can't get homeowners insurance. They can't receive basic system repairs, which is free grant money to help them repair and maintain the house. They can't get home equity loans so they can send their kids to college, or so they can't make any payment arrangements with the mortgage company if there's a mortgage there. They literally can't do anything because the person died without the will. And so by the time they get to you, either they had a will or they don't. And so one of the things, because some of y'all serve also as pastors and bishops, is I would like to make sure that we come and speak to your parishioners about the importance of making wills. Because in the state of Pennsylvania, if you don't make the will, they have already made a will for you, and it's called intestate, and it favors biology. So whoever's your next of kin. And sometimes that may not be who you want to get your assets. So what does it mean to register a will? So people get mixed up with the registering of the wills. And I wanted to let you all know, I'm not sure who your audience is and who your constituents are, but everything that I'm telling you tonight and everything that you're going to get from me and all the advice you're going to get from my solicitor and attorney, Terry Booker, it serves only in the state of Pennsylvania. So if you're talking to somebody from Jersey or Maryland, Connecticut, what I'm telling you may not apply. So when you say register of wills, people think, oh, I'm gonna get a will and then I come down to the office and register it. No, not in the state of Pennsylvania. In the state of Maryland, yes, you do register a will. But in Philadelphia, we do not register wills. By the time we see that will, you're already dead, and either whoever your attorney or your executor that you name is the person that normally comes out and bring that will to us, so we can bring the processing of the probate, so we can be able to give you the short certificate, so you can go and obtain those assets. So we'll go over what a short certificate is. We also going to provide you a flyer, and we're going to give you direct numbers on who to call and who to email when your customers come to you and they go to the bank and the bank say, I need a short certificate. And we're going to teach you that that is not necessarily always true. Yes, you do need a certificate to be able to get money out of the bank of the deceased person money if you are the mother, the father, the spouse, the parent, or the siblings, and you can show proof of that along with a death certificate. But if it's more than $10,000, they will not release it to you. You have to come to us to get the short certificate, and then you have to go through the probate. If it is $10,000 or less, they have to release it to you. And my solicitor will explain that to you, and we will provide you law that you can take to the office or call our office for us to contact that bank. I am currently planning to meet with the Bankers Association so they can be updated because I think they believe it's still 2,500, but it's up legally now to 10,000. So if you got $10,000 in one set, you got to come to our office and get the short certificate. If you're at $10,000 or under, you have to go there and show proof of relation. And I told you those relations: mother, father, spouse, brother, sister, dad, a death certificate, and a funeral bill. And they have to release it to you. So Sharon will go over that with you as well. When the descendant dies without a will, that's where the problems come in. Because they still have to come to our office for the probate, but it has to be determined who will be the heir. And in many cases, that's what some of the challenges are. Because we don't, the person don't know who the heir is. Somebody could think they're the heir just because they were taking care of them and they were the niece, but they had children. And so the children come before nieces and nephews. And then testate, we will send you how you can go by the family tree branch. And all this is causing a lot of problems with you all and a lot of problems with families because we are scared to leave wills. And that's something that I think with that lack of financial literacy is causing us to lose a lot of businesses and loads of land. Within the next 25 years, $68 trillion of generational wealth will transfer from one generation to the next because the baby boomers are getting older and they're dying. Within the next 25 years, $68 trillion will transfer. And we want to make sure your wealth is transferred to the person that you want that wealth to be transferred to so they can continue to conduct business. Right now, once the person dies, the family is literally pretty much kind of like a squatter because they cannot do anything legal. Even if it was a natural catastrophe, you could not even get FEMA. And FEMA is different from insurance. Insurance is you pay into insurance and is a claim and is a loss, and the agent determines whether or not that loss is covered and they pay you. FEMA is when it's a catastrophic loss, and whether you have insurance or not, the government bails you out. You are not eligible for that if that house is still in dead mom's name, and dead grandpa's name, and dead auntie's name. You can't do business, and that's what's becoming a problem. You also wanted to know what do I need when I come to the office to open a estate? We have literature that's going to go to all of you all in the form of a flyer, and it details what you need: the death certificate, renunciations, whether or not, with the will, you bring the will in and out within like half an hour. Without the will, then, it's some more things that before you even get to come to us that you have to secure. We have all the forms for you all digital that you can print out. And we also have some that is already printed out if you want to put I'm sure all your churches have a constituent service person that deals with that. We have those flyers that you can hang up. And then when you can't find the original will and you only have a copy of the will, that problem can be solved as well, because you just will ask for a citation hearing and you come before me and my staff, and I will do some research and determine whether or not we can validate their will. I've done them before. And some of the problems is people hide their wills and they don't tell anybody where they are. If nobody knows where your will is, then you don't have a will. If you don't tell anybody that your attorney has your will, how would you know? It doesn't count if we can't find it. And so we're trying to teach people to not only let somebody know where they will, but safeguard it in their house a box that you can get from Home Depot that is both fire and waterproof, and you can tell somebody that you trust that here's where my will is, and and here's the person that I want to be my executor to represent my estate, because that's why they call it the last will and testament. So when you die, you still got to pay your debt before you disperse of the assets. And of course, part of the debt is that funeral bill, which is very important. And so wills is simply a document that you write during your lifetime to distribute your assets. Your will is not effective until you die, and you have to be 18 years or older to make a will. We do not store the will. You store the will and you let someone else know where your will is. A valid will in the state of Pennsylvania has to be signed at the bottom. If you write your will and you sign it at the bottom, that can be upheld. We can validate that will once your heirs or your executor comes in, shows proof of signatures. The only difference is that will can possibly be challenged, and oftentimes it is. So the best practice is to make sure you go to an attorney. You go and take an attorney that specializes in wills and estates, not car accidents and homeowners insurance. You want somebody that is their specialty. That's why I hired my solicitor, Sharon Wilson, because that's what she specializes in. And I seen it was a problem in the city of Philadelphia with us not understanding not only the importance of a will, but the importance of letting people know where that will is, and the importance of learning the rules that govern a valid will. And so these are the things that that we're going to teach you. So when your customers come to you and they have those problems, we have everything written down for them, simplified. You're going to have to connect with Vanessa. Vanessa is going to be able to contact me, and then my employees will be able to expedite your claims.
Can I add one?
Okay, we're asked to hold the questions later. Just write it down.
Can I add one more thing to what you're saying?
Yes.
That needs to be notarized.
What needs to be notarized?
That will.
No, it doesn't. It has to be notarized.
Doesn't have to be notarized?
No, not to be valid in the state of Pennsylvania. No, it does not have to be notarized, but that's a best practice. In other words, you could actually right now, because you can't get it out because COVID, you can actually write your will, write your assets, write who you want them to go to, and sign it. And we can validate that if once your executive come and they show proof. But that's not a best practice. Sharon is going to tell you a best practice on the type of will, but remember, you can write your will right now on a piece of paper, assets, who they go to, and sign it at the bottom. And when you die, whoever you left that written piece of paper, they bring it to us and they prove it and validate it, and prove that this is your signature and there's no one contesting it. In the state of Pennsylvania, you do not have to have a witness, nor do you have to have it notarized. But it's not a best practice. It's not a safeguard.
Actually, what Reverend Price talked about, the will in fact being notarized, is the best practice. Now, Pennsylvania says you can write your will and you can sign it at the bottom and it'll be legitimate. But the best practice is to get it notarized, because what makes it legal doesn't make it validated. So what would validate your will is that notary signature, not only of the person that signed the will, but the notary signature affirming the witnesses that signed the will. So the best practice is to, one, get an attorney to draft your will. And that's because if you do it wrong, we can't accept it. And even if you do your best that you could, we can't accept it. So then you're back to being somebody that doesn't have a will again. So take the time to get somebody that knows what they're doing, do the will. And when you do that will, make sure that the attorney makes it what we call self-proving, which is to have it notarized by the person that signed it and also notarize the two witnesses. Because if you don't do that, when you bring your will into the Register of Wills office, we may have to locate the witnesses to the signature on the bottom of the will. And that can be very hard, especially depending how old your will is. And if we can't locate the witnesses, then we have to locate somebody who knew the witnesses, who knew the signature. It can get kind of complicated over something fairly small and inexpensive to do.
Especially if there's going to be some bickering that's going on. And I'll get to that because we have it a lot. We have a brochure called What a Difference a Will Makes. And we have those available, and it's also available digitally. And it will break down everything you need to know about the importance and what a difference a will makes when you die. And also we have a brochure that you all will get. You get legal assistance for people that can't afford. We have so many clinics out there that help Philadelphia Legal Assistance, Community Legal Services, Christian Legal Clinics, Drexel Stern Community, Senior Law Project. We have all Drexel Klein School of Law. We're going to send you all this flyer digitally, and we should be able to send a hard copy as well. So you can start giving it out to your parishioners. For those who can't afford to make a will, they can go to them and they help them create a will. Those that can't afford it, like we can afford Louis Vuitton and Chanel and whatever we, spend our money on. It is very wise that we should spend our money on once we accumulate the asset, not once we get old. Once we accumulate the asset, that the will should be made, especially if you own property, if you have minor children, if you are taking care of children with disabilities, even if you're taking care of your parent. This is one of the problems that's coming up without the will. And then the fighting that goes on, and you're dead, of course. So you don't know the problems that you cause simply by just making a will and just writing out, this is how I want, this is who I want to inherit my things, whether it be my jewelry, my picture collection, my teapots or whatever. I'm not here to determine what your asset is. You know what your asset is. You know how much it's worth. All we're saying is we have to start teaching people that they need to put it in writing legally and make sure that they get the affidavit so you won't have to go hunt down those two witnesses. And then they could just come in the office with the death certificate and all the things that we're going to give to you and have all that in order. Because basically what I would love for everybody to do is put the will and all your important papers and then put the checklist of everything. Here's where my driver's license is. You need proof of my signature. Here's my birth certificate. Here's my divorce decree. Here's my marriage license. Here's everything that the executor needs to know when they come to our office so they can get in and out of there, and then they can pay that debt, which includes your funeral bill, and then they can disperse of the assets. So another question that I see that I wanted to explain to you all before we get to the short certificate is, Sharon, could you explain to them the law behind the ability for the relatives to be able to go to a bank and retrieve the dead people money so they can pay the expense of the funeral expense and any other expenses that is incurred that continues even in your death?
Well, there's some expenses that they prioritize under the law. And of course, funeral bills are one of those expenses. So there's an understanding that often it takes time to raise an estate. It takes time for those things to happen, and you need those monies right away. And that's why they do allow relatives, in the order that the register mentioned earlier, to go into the bank and actually, with a copy of a death certificate, person needs to be dead, and a funeral bill that needs to be paid, they allow you to do that and go in and actually extract the monies. I'm sure that some of you probably in your capacity as funeral directors have often went to the bank yourselves. And you know that with your funeral bill, if you don't know that, you should know that with your funeral bill, of course, you could go in and extract the monies. Particularly if there's a burial reserve account, which is specifically just for those expenses. With the funeral bill, you can go in and you don't need the family to accompany you, and for a burial reserve account, and you can extract those monies from that account.
So $10,000 or less, if they go to the bank and the bank refuses to release that money, you tell them to go directly to the, I wouldn't even go to the teller. I would just go straight and ask for the manager. And if they give them any problems, call Vanessa, email us. We're going to give you all our email addresses. And I have deputies that have relationships with a lot of these banks, and we will make sure that they release those funds. If it's $10,000 or more, still send them over to us so we can, right now we're working appointment only, but we make special exceptions, and I certainly would, you're going to be my friend, and we're going to make special exceptions so we can get them in there so they can get those funds, so they can pay off the debt, and they can move on with the process of settling the estate. And so one of the things that if it's $10,000 or more, you go to the bank and they tell you that, they're going to say, you're going to need a short certificate. And of course, who knows what I just learned what a short certificate was. College graduate and everything. I'm like, what is a short certificate? I didn't realize the impact. And in my personal family, we have lost a huge amount of generational wealth just because of these technicalities and not understanding the legality in the state of Pennsylvania around securing your assets. And that's something that I'm talking to the state legislators about, and I'm talking to city council, because we're in a crisis right now. We are in a crisis of just, the tangled titles, and just the fact that we're not literate enough to understand, yes, you can own property all you want, but you need to know the legal rules around owning property in the state of Pennsylvania. So when you die, your estate will continue to be handled so you can transfer it down to whomever you want it to be transferred down, and not let the state determine who that's going to be transferred by way of intestate. And so now, before we get to this another program that I hope you help me to get out to your parishioners, Sharon, explain to them exactly what a short certificate is legally.
Whenever you go in to probate an estate, whether it's with a will or without a will, you'll get a document. It'll be called letters testamentary if there's a will, and the letters of administration if there's no will. It's a nice long document with a bright gold seal on it. Some of you might be familiar with that document. But the thing is, when you go to retrieve assets, the people that are holding those assets, they're not just satisfied with your letters of testamentary showing that you have authority to gain assets of the decedent. They want something more recent. So a short certificate is just a certified document that is most of the times, no more than 60 days old. And the financial institutions want that because they want to make sure that there's no fraud going on.
Right.
So they want to make sure that that what they're looking at is new and fresh, and it's not that letter of administration that you got 9 months ago. And once you probate the estate, you are eligible to get a short certificate. And usually in a short certificate, you have to detail exactly the name of the institution that you're going to.
Right.
So they want to know that it's new and that it's specifically for them. So that's what you do. And once you get that short, you can get more than one if you need it. But you call over, and I know that information, some of it is in the chat and some of it is in the information that Mark is providing to you. But you can call over or email us a row online if you need that, or you can tell the people that you are in contact with that's what you need to do in order to obtain one of those short certificates. They don't take that long to get. Usually they're pretty fast about the turnaround. You can get it in as quickly as 3 days. But well, I shouldn't say it will be a small cost attendant to it.
We're going to provide you all with a list of legal communities that come. They will even, I know for a fact that Christian legal clinics, they will set up a clinic right at your church. They will set a clinic up right. Terry serves volunteers on that committee, and I've walked into several clinics where the people walk out of there with a will, a legitimate will, and just they give them the information they need. Now the thing is, when they die without a will, which many of us are doing, and that's when it becomes complicated. And that's when, and that's where, you're frustrated. So one thing we want to start doing is we want to prevent that. But in the meantime, we got people that's sitting around dying without wills, and you're crying and you're upset. You can't even really mourn your relative because you got to conduct business. And it's everything is nice. Going to the funeral directors, make sure that they look nice in the coffin and they whatever. But it's an expense, and it's an expense that sometimes is it's kind of embarrassing that you don't know what this paperwork is, and so that's why I'm being very aggressive with teaching people how to mind their business, and how to make sure that you don't leave your family in this frantic state after you die. They're able to mourn their children, mourn the death of their loved ones, get the piece of paper, make the appointment down with the Registrar of Wills, because right now, of course, because it's COVID, it's appointment only because we have to protect our staff, and we can't just have people just dropping by. But we will definitely make sure that we prioritize your clients and fit them in, because we can do that for you all as well. And so when they die without a will, particularly if they own property and cars, bank accounts, stocks and bonds, it causes a lot of confusion. And the state of Pennsylvania pretty much anticipated that this probably would happen. And so a process called intestate is when the state of Pennsylvania already made the will up. And Sharon is going to go over with you just some of the challenges that you have without the will, and the process that you have to go through, which is going to be a longer process. And so we can't even put a timetable on it, because, if the next of kin lives in North Carolina, or one of the next of kin lives in North Carolina, getting those papers over him for them to sign over renunciation so you can become the administrator is time consuming, sometimes difficult, and sometimes even impossible.
When you draft a will, it's like, think of it as a straight line from you to your assets, and then to the person that you want to have your assets. When you die without a will, it's like a squiggly line. And those squiggles are what kills you. So with a will, I go in, the witnesses, it's been notarized, I give it in, and as the register mentioned, most of the time those folks at their appointment, they're in and out in 20 minutes. They take an oath and you go forward. If you die without a will, there's a couple of things we need. First, we need all of the names of the next of kin. They have to be listed on the paperwork. And then we need permission from all those other folks that you, or whoever's bringing that will to us, have the authority to go forward. And let's say you have 3 brothers and sisters who are next of kin, 2 of them agree, 1 of them don't, then you can't go forward. Then you have to have a hearing. And in order to get a hearing, you have to file a petition. In order to file a petition, most people have to hire an attorney. So if you don't hire an attorney, we do have a staff that'll try to work you through it, but we're not allowed to give legal advice. We can give you format, but we can't give you legal advice. So you may end up having to secure an attorney. Once you get an attorney and you file a petition, then you have to wait for us to give you a hearing date. Then once you get the hearing date, you come in and you or your counsel, and we listen, and the register makes a decision about whether or not you should get it or whether or not you shouldn't get it. Now, the register is a nice person, but I wouldn't advise anyone to leave it up to a third person outside of your family who's going to determine who would be the administrator of your estate. You have the ability to do that, so do that. And not only now have you caused delay, which sometimes means that the funeral bill isn't getting paid, right? And other expenses aren't getting paid. The mortgage may not be getting paid, but now there's also additional cost if you have to hire an attorney or file that petition. And then once you do get the information, if you are successful and you go forward, then you have to go back to probate and stand in the back of that line and get the estate probated. So not having a will can cause a lot of delay, additional expense, and a whole lot of headache. And remember, once you have that hearing, and when your siblings or whatever the other family members are that are on both sides, on opposite sides, the likelihood is that you will never talk to that family members again. Not in any civil kind of way.
Oh, no, you won't.
You're not going to birthdays together. You're not celebrating together. None of that is happening. That's not going to happen. So the thing is, if I'm, for example, probating my mother's will and it does a certain thing, my brothers and sisters know that's not me talking. That's my mother talking. But when there's no will and you go in to say, I'm the one that should probate the will, that's just a brother and sister fight. And that's the fight you've been having since y'all were 8 years old about who's going to do what, and you can't boss me. So all of those kinds of issues and those emotions come up. So if we can, we want to avoid that. As the register mentioned, you're already trying to grieve a death. And this business of death can just prolong grief, cause you money, cause delay, and really put stakes in emotional relationships between family.
I just heard a hearing the day before, because we are holding virtual hearings because we didn't shut down at all because of COVID. We are essential workers, and we maintain because people were dying and people needed to get married so they can get the benefits. And we whipped our operation and made it so we can work. We still show up, but some people work from their homes as well. And I was listening. I had a hearing that I had to hear. No will. The son was residing in the home. 2 brothers. He was resided there to take care of the mother, in her sickness. And then his daughter moved in, and according to his testimony, she helped take care of the mother. The other brother didn't live in the house, but she died without a will, right? So that means the next of kin was the 2 brothers, the one that's living there and the one that's not. And so the one that's not hired attorney, and you should have seen their testimony. They did research and criminal background checks on the daughter and the son, and then the one that was living there, maybe, just maybe, his mom wanted him to have a house or wanted the granddaughter to have a house. You hear it all the time. I used to hear, I want to see my granddaughter this house. It doesn't mean anything verbally at all. Does not mean anything verbally. I've had people come crying to me. My grandmother raised me. This is all I know. This is the only house I know. And I don't even know the business of, I thought this was my house. And that's when the mudslings. And I have seen wives fly from out of the country. They thought that they were common law married, which, by the way, no such thing as common law in the state of Pennsylvania since 2005. So that's something that we need to preach on to. When we get in here, if you're married, you're not married, there's no such thing as common law. I know you was with him for 35 years, but being able to come into courtroom and prove that, along with the people that if they were married before or they had previous children. It's just so very complicated. I was reading, the solicitor has a book, Mind Your Business. I recommend that you all get a copy of that and read that book, so you can really understand the just the confusion. It's really sad. And I have to sit there and I have to make a decision. And of course, I want to preserve the generational wealth. But the brother has 50% stake in that house. And unless you're paying him rent, if he wants to pay the rent, wants to accept the rent from you, you might have to sell that property that your mother might never wanted it to be sold because she didn't want to take the time. And I can attest to this from my grandmother. She came from that generation that they didn't really like to make decisions, and they didn't like, they don't want to choose, or, they don't want, I just don't want to talk about death. And whether they want to talk about death or not, when they die, it's going to be problems for your family. And I'm sure you all have heard these stories, and that's why I had to come up with a program about on how we can get your clients and my clients out of these tangled titles, because they're living in these houses that they don't own. Whether you have ownership right into it or heir property, no such thing. There are legal things you have to do in this country, but particularly the state of Pennsylvania, to secure your wealth and to make sure that it is transferred down to the heirs that you want it to be transferred to. Sari, just briefly tell them about this wonderful program that we put together here at the Registrar of Wills to help people that are living in houses that are in dead people's names, sometimes 3 and 4 generations back, which means they have to open 4 and 5 estates, which costs a lot of money that you don't have. When simply, if you would have made the will, you wouldn't have to go through this process of opening all these estates. So we're going to try to help people, and we hope that you all can let your parishioners know about a wonderful program we started called Probate Deferment Initiative, because the legal community was telling us that the fees was regressive and the people could not afford all these absorbent fees in order to transfer the title out of their name so they can conduct the business. And so we started a program that can help them with this in partnership with Philadelphia VIP. Philadelphia VIP is the organization that get funding from the city to address tangled title, but it just wasn't enough money. And so we decided that when they come, if they qualify for our program, that we would defer them. And Terry, could you explain to them a little bit more about the program? And we are going to send you flyers, and you will get information on how you contact lawyers to help you with this information.
Yes, thank you, Madam Registrar. Good evening, everyone. As the Registrar already stated, she has a dedication to helping to figure out this tangled titles and help crack down with the tangled title crisis here in Philadelphia. And the Probate Deferment Initiative is designed to help with that crisis. People who cannot afford to pay those fees that she just talked about, 3 and 4 estates, $500, $400, $300 a piece. Those upfront fees are a lot. So it's designed to help people pay those fees. And what we do, we don't waive the fees, we defer the fees. So they're deferred to for a later date, for when you have the ability to pay. If you decide you want to sell the house, then you can pay the fees, but you can't do anything. You can't handle any business until the estate is open. So once you open the estate, you'll be able to conduct the business of the estate. And if there is money, or if you do sell it, you can pay us our fees. And we had the good fortune to Commissioner Leonard, James Leonard, he allowed us to, anyone who is a participant in the probate deferment initiative, he is providing a recording fee waiver. So you don't have to worry about the fee to change the deed or anything like that. So that it doesn't include the transfer taxes, but the recording fee, if it applies, transfer taxes may or may not apply, but the recording fee is waived. So then what that means is once you create that new deed, you can get it recorded at the deeds for no cost if you are part of the probate deferment initiative.
And from there, we are going to assist them in making a will. So it won't pass down to generations and become a tangled title again. That's a huge initiative that we are putting out. Listen, we want people to stay in their homes. And of course, they was trying to give us or taught us, it gave us the impression that Philadelphia row houses, the ghetto, it don't look too much like the ghetto anymore because you can hardly buy a house here anymore. So we want to make sure that your parishioners get those houses out their people's name so they can get the benefit of the basic system repairs, just the benefit of being able to say we own it and be able to pass it down to generations. And so before I go into the difference, because a lot of people confuse our office, they think I'm the recorder of deeds. I am not the recorder of deeds. I am the Registrar of Wills. We do not record, we do not transfer deeds. That is Commissioner Leonard. That is a city office. I'm just the Registrar of Wills. So you come to me to probate it. Then once you probate it and you get all the paperwork done, and then you go over and make payment arrangements to pay the estate tax. Then you go over to the recorder of deeds with the paperwork and get the title transferred in your name. But you wanted to know, what do you need when you come to our office to open an estate?
Now, the process of probate, like as the registrar said, you have all that information in your packet, so I'll just give you the summary version. And the process of probate is you have to come down to the Registrar of Wills office. We do have some remote appointments available for those who have attorneys, but otherwise you have a remote appointment. You have an in-person appointment at the registrar's office. At that time, you're going to bring your death certificate with you, a copy of the will if you have one. You have to have a valid photo ID for whomever the proposed administrator or executor is. You should have an estimated value of the decedent's assets because you pay fees based on the amount of money that are in the estate. You don't have to have an exact number, but you should have an estimate. And then in terms of payment, because there is a fee for that, and the average fee is between $300 and $400 per estate. So you have to pay by either Visa, MasterCard, money order, certified bank check. If you are represented by counsel, they can actually use a attorney check. Now you could be asked for some additional documents though. You may have to have a long form birth certificate and that displays the names of both of your parents. Depending upon, your name may not look like your parent, or your birth certificate doesn't have the name of your parents on there, so it can't be validated. So you may have to have that type of birth certificate. Also, you may have to have a marriage license if you're saying that I'm the spouse of this person. And you may have to have a divorce decree if you were somebody else's spouse at some other time. And you may have to have renunciations. Those are those consents that I talked to you about earlier that you need from other family members if you want to go forward. The way that other family members give you consent is by signing a renunciation.
So Title 20, Chapter 3101 is the most important thing that I think you all should take from this meeting, this first of, I hope, many. Being able to go to that bank and retrieve that money so they can pay the funeral bill. So when you go to the bank, we put this in your package. They have to provide a death certificate and the funeral bill. And of course, they're still responsible for the proper distribution of that wealth. And if the funds exceed $10,000, they have to file a petition to obtain the rest of the monies. And so that is something that I wanted you all to know. Not only are they not, the deceased person is not preparing whoever their executor is going to be, whether it's your youngest child or the child that you feel is going to be the most responsible, because just because you're the executor don't mean you're going to get any more money than the heir. So you can serve as an executor and not even be an heir. You might pick somebody that that you might don't want to pick none of your children, and you pick somebody that's neutral, that you trust, that is going to go to the letter of how you want your estate to be dispersed. And a lot of times people think they're going to avoid the inheritance tax. So we put a package in there so we can talk to your customers and clients and let them know that whether you think you're going to avoid it or not, it's still calculating. But the difference is it's calculating with interest. So if you pay it within a certain amount of time, you get like a 3 to 5% discount. But if we pay it within 9 months, there will not be any interest. After 9 months, the interest starts ticking. That's the bad news. The good news is you're only taxed on how much the property was worth when the person died. So if your grandmother died in 75 and you're living in that house, it's going to be taxed on how much that house was worth in 2005 or 1995. And so that's the good news. And another thing about estate taxes that you do not want to avoid, you can actually make payment arrangements as low as $25. My concern right now is to make sure that they get the property out of the dead person's name so you can benefit from the property, whether you want to sell it, you want to take a home equity loan, a small business loan, a small interest loan to fix the house up, or simply that you want to set it up so you can leave it to your child or children. I think we covered basically everything. This is marriage and common law marriage. And I get a lot of, families coming in that literally think they are married just based on the time they spent with someone. And in some states, it applies. Unfortunately, in the state of Pennsylvania, since 2005, it's been abolished. There's no such thing as common law. So if you are in some type of complicated situation, you want to encourage your will. You definitely want to encourage your will. Sharon is just going to briefly tell you some of the challenges you're going to have to prove that you are the wife, and or the husband, for that matter. I'm not going to be prejudiced because some men are common law, or they think they are, until those kids come in and say get out. And so I've seen that. In just a year, I've seen it. It really gets ugly. So Sharon, this tell them rule, because I think we're talking to pastors and reverends, and you all married people, and you all have the girls, and when y'all have your sermons, and I think that at a young age, both men and women need to know the business of marriages. And love is a many splendid thing, but marriage is a business. It was a reason why it's contractual. It's contractual, and it is a business, and people need to understand the business of marriage. Sharon?
I know that I'm talking to people who already understand this, because when I attend a funeral and I hear these 3 words, I'm the wife. That's when I open my pocketbook and take out the popcorn, because I know there's getting ready to be a show up in here. So this is what I want you to let your constituents know. There is no common law marriage after 2005. Yes. So if you're trying to prove common law marriage, you had better established it before 2005. Because if you can't, there's nothing for you. And not only in Pennsylvania, but most states don't adhere to common law marriage anymore. And the thing is, they really did it to support women because so that they wouldn't find themselves in this position thinking that they were married. But people haven't gotten the message. To establish a common law marriage, you have to establish that the two parties intended to be married. So maybe they wear rings. Maybe they refer to themselves as Mr. and Mrs. Maybe they filed joint tax returns together. Maybe they held themselves out to be married to other people. And remember, you can't already be married and be in a common law marriage. So you need a legal divorce to be in a common law marriage. There is no common law marriage at all for same-sex couples in Pennsylvania. It never was. So that's just totally out of the box. So even with all of those things, it can still be very hard, especially if you have family members on the other side saying, no, they're not married. They're not married. And this is why I know they're not married. He told me he would never marry her. Or she told me she would never marry him. So it just invites all of these other people in to comment on somebody else's relationship. And those comments get to be legal, right? We've tried to determine some legal benefits. And you know that marriage, whatever else it has, it still does have some legal benefits here. It will determine the order of priority in terms of who takes assets, who will control an estate. So that's the thing that you let your parishioners know, that no, there is no common law marriage. And even if you prove it, it's very hard. And you be proving it in front again of the register. Initially, you prove it in front of her. And whatever decision she makes is subject to appeal. So other family members could say, no, I don't agree with that, and go one to the next court. So you want to take yourself out of that if you can. Now, if they do not want to get married, then you need to make a will, because now you have a situation where the law will dictate what will happen. And if families come in, then it's all over.
And I'm telling you, I have to go by the statute. I have to go by what the law says. And listen, I know you all have seen this, because I'm not even a pastor or anything, because you all are, are closer to, matter of fact, some of you all are closer to your clients than they are to their own families. And I'm telling you, these people will come from down south. I had somebody fly from Africa and had her, I'm the wife. Like, listen, we need to discuss this. We need to start talking about generational wealth, wills, estates, heirs, who I want to conduct my business, what debt I have. It just has to be a conversation. Some of the reasons why we were ran out of down south, because of land. They were taking the land. They got jealous and they just literally took the land, and hundreds of millions of dollars worth of land loss. And then in Philadelphia, it's back when you could qualify. I think maybe I was probably the last of the generation that could actually go into the bank and try to get a mortgage for a house. They look at you now, and you have to have perfect credit, 20/20 vision. I mean, it's all kinds of things that they're making you come up with to even buy a home, not to mention how much homes cost. So the little bit of homes that we have and your parishioners have, we want to help them stay in their homes. We want to. But mainly, we want to make the transition from your death and from you all coming to our office. We want to make it easier. We want to make it accessible to you all. And thank you, Vanessa, for having me. She has my direct contact information, and some of you all have it as well. Calling may not be good, but texting is good. We are on all social media sites: Facebook, Instagram, Twitter, LinkedIn, even on YouTube. All you got to do is put in PHLROW on Instagram or any of those websites. Email us row.online@phila.gov. Any other questions that you have, any personal questions that you may have, how we can help you, send them over to Mark. Mark can send them over to Vanessa. She can send them to me, or I'm at tracy.gordon@phila.gov, and I read all my emails, I refer all my emails, and I follow up on all my emails. I have a staff that get up every day and come out, whether they're on a train or on the buses. In all the conditions, we come out to make sure that you all are serviced, making sure that your parishioners can get married. We're making sure that when somebody dies, we will call that bank and say, release that money based on the statute that I just gave, Title 20, Chapter 3101. That's the law. Release the money if they have all those things. Plan, prepare, protect. I basically answered all the questions. I know we ran out of time. I know we getting ready to zoom out. But Reverend Collier or any of y'all, you have a question or two that we can answer for you before we tune out?
No, I appreciate the opportunity, but I will certainly be in contact with Vanessa as well as your office, because I want this information to go out to all the members of Black clergy of Philadelphia vicinity, because we represent a lot of folk. And I know that we have some people that desperately need the advice of your office, and they need to see someone who looks like them to help them navigate through all the ifs and ands, and they need these ands, and they need somebody who can talk to them in the language that they understand, because all my folks have not been to Princeton.
Right.
Right. They need to be able to talk to somebody.
And people are scared, Reverend Collier. Like you're like, oh my God, like I don't know what mom business. I don't know who the mortgage company is. This was in my great grandmother's name. Where do I start? Right, and so sometimes you're so scared, because this has happened to me too. You're scared that you just say, I'm not going to open that envelope. I'm not going to think about it. And you're scared. That's why we're gonna talk to them in basic terms. We have such a courteous staff. They really go above and beyond, and we have partnered all these. I couldn't believe when we have all these people don't even know it, and they're doing it remotely. These clinics, they will come to your church and hold those workshops. And call your state representative. You tell them to call the state representative, because they have booklets that you should ask them to send you some for wherever your church is. Call that state rep or state senator and ask them to send you those manuals. They'll be glad to, because they advertise their name. But those manuals where it says, it has a family tree, and you put all the names down, and what's your insurance company? Where's your assets? That have them fill that out, and then every week they come in. Did you fill this out yet? Did y'all? Can the church hear amen? And did you put it in a safe deposit box? I mean, not safe deposit box, because we're saying don't put them in a safe deposit box. Put it in your house in a box, because if you put it in a safe deposit box, they're going to have to come to us to get permission to open it.
Mm-hmm. Yeah.
Don't put it in a safe deposit box. And so that's why we're on social media, but our seniors they're not into the social media. But just like I tell people all the time, most of us is paying those bills for our kids or grandkids, those cell phones. They are very smart. They know what Zoom is. They know what hey, I need you over here. You tell your parishioner, I need you over here at 5:00 on Saturday or whatever time you're going to have us on, with your computer or this phone, and here, log this in and hold it up for me while I listen to this important information, so you will be protected if I die. That's how you have to do them. Will you do it? No, you're going to do it, because we pay the cell phone bills, and I'm your grandma or I'm your mom, and you got to help us. Just like, I had to call my kids when they did the Patti LaBelle. I don't know if y'all seen the Patti LaBelle and the Gladys Knight when they did the verses. And they had a meme out, because I was like, I called, I said, I don't know, get over here and show me how to put the YouTube on my screen because this is a free concert. But I didn't
Hold
know
on.
how to navigate it. And I'm pretty literate with the computer, but those kids, they don't have to read directions. They already know how to do it. So if they can't take out an hour on a Sunday or Saturday or whatever day you're going to bring us to and hold that phone up in that computer for grandma or grandpa to hear this importance, then cut the phone off. No,
I think I saw Mr. Price's hand up. Mr. Price, I think you had a question.
yes.
Yeah, first of all, me being the only funeral director that I'm seeing up here, feel free to call Price Funeral Home at any time. I have a
Okay.
special booklet that I give the parents, anyone that comes through, and
Really?
and has that information in. That same information, a couple insurance companies give that booklet out when you apply or call them, and they say free this or well, it's free, and we have it. I do appreciate, and I want to say it like it is, Miss Brown, Miss Gordon, Terry Booker, Miss Wilson, and
Mr.
Bro,
Zimmerman.
Mark
Mark
Whittle.
Arrell.
I really appreciate you because I know I'm the one that went to Miss Brown and said, I need to talk to them down there out of all the funeral directors because we were having problems with families coming, having a lot of assets, and they wanted to bury their families properly. To the ministers, help the families. If you have any question, you don't have to bring them to me. I will gladly get on the phone and walk you through anything. And you know that, Nesbitt. I will walk anybody through anything.
I
So
would like a copy of that book because we be able to feature it. I might get
I
some.
will see that you get a copy.
Thank you.
Thank you very much.
And I'll get the book from Mr. Price and get that to you, Commissioner Gordon.
Well, thank you, Vanessa.
And Bishop Coates or the Black Clergy, Archbishop
Bishop
Mary.
Collier.
I would love Collier. Yes, I would love to come and talk to your fellow the clergy because, like I said, that they look up to you all. They really do. I look up to you all.
I'm going to also acknowledge Archbishop Mary Palmer is on the line. And
yes, I acknowledge her. Yeah. I've been on her radio program many times. Pastor Twyman. I am really hands-on, and so is my staff. And we can do this. We can do these Zooms, and we can keep doing them and doing them and doing them over and over until it becomes the fabric of our life again. Somewhere along the way, we stopped making wills. Mm-hmm. And that's very dangerous because that's a rule. You do not want the state of Pennsylvania making the decision on who your hard-earned assets go to. That's your decision. But now we got to deal with it because we got people living in grandma and great-grandmother's house, grandpa and great-grandparents' house. And these houses are either going to be lost because they can't maintain them, or that's why you see all these abandoned properties and stuff. And then you know that you have parishioners that don't have heirs, that don't leave a will. And guess where that property goes? It goes to the state of Pennsylvania. And right now, you should see how much is sitting in that treasury of unclaimed. The Catholic Church inherited lots of property from their parishioners who would leave their properties to them. I know someone who purchased a lot of properties from the Catholic Church because the parishioners who didn't have any heirs would just heir it to the church. I would rather see property be heired to the church as opposed to sitting up in the state in the treasury. You all could use those properties for affordable rentals or whatever you wanted to do for your parishioners. But the fact is, you have some parishioners that are dying that don't have any next of kin. And then therefore the house just sits there and rots, or somebody still figures out a way to steal it, or it goes to the state and it just sits up there in unclaimed properties, sitting there just wasting away. And so just keep mindful of that, you know, the heirs of people that own property, even if they don't have heirs, they can leave the property to the church. And it's legitimate. And the Catholic Church has done it for years for their parishioners. So keep that in mind as well.
Well, this has
Thank
been
you all.
very beneficial. This is Bishop Coates. This has been very beneficial, you know, extremely. I did reach out to the Baptist Resource Network moderator, but I will definitely reach out to him again.
Thank you.
I wanted him in on this, and this was short notice.
Right.
Vanessa contacted me, and I reached out to a few of the other pastors, but the Baptist Resource Network, Baptist Convention of PA in South Jersey, they definitely need to be in on this.
Listen, we do this weekly. And so the next one, I mean, we're pretty loaded for the next 1 or 2 months, which gives you time to advertise it. We could even have a little short conference and we can send those packages so they can study them, write their questions down, send them to us, and then train some more people, because we are behind the 8 ball in this city. I'm telling you now, we are very behind, and people, where they gonna live? Rent is sky high. That row house is very, it's worth a lot of money now, by the way.
Yes, it is.
So at least you won't be selling out of desperation. You can say, hey, listen, I'm selling, but here's the price.
Right.
And so I just wanted to let you all know. I'm gonna get you in contact with Recorder Deeds. He has a program over there that we send the flyers called Fraud Guard, where you can call and register your house and leave an email. So therefore, if anybody's over there trying to steal your house, you'll get a notification. So it's called, we put that in the package too. But we ran out of time. I'd like to thank you all. And Tasha's on, she's just listening. That's another one of our outreach team. She's put together some wonderful packages for you all. And we made it digital. So, you know, get those emails from your parishioners and tell them to look at these emails. And you might not send them the package. You can just say Daily Bread. We're going to send out once a week, and then we're going to talk about what a short certificate is, and we're going to talk about what you know, why you need a will, and then here's some legal places. You don't have to send them all out at one time. You can just send them out once a week. It's different information, and keep rotating it. Each one teach one.
Great plan.
Yeah, I'm gonna say hi to the Reverend and this is my granddaughter, guy. She's over here. This is my little generation. Say hi. Yes. So this is why we do it for her, so she don't have such a hard time, you know, because Lord knows when she gets time to own a house, you might not even be able to afford it, like in New York. Who can afford to buy a house in New York now?
That's right.
Unless you're a millionaire. So thank you all. Have a good night.
This was wonderful. And I hope everyone got as much as I got out of it, because I really learned a lot tonight. So thank you.
Thanks, Sharon. Thanks, Terry.
Thanks, everybody.
Thank you. Good night,
Thank you,
everyone.
Good
everyone.
night.
Right.
Everyone.